This courtroom exchange explodes before the judge can even finish saying good morning. What you're about to witness is not just a routine bond hearing. It's a volatile mix of criminal allegations, probation history, race-based accusations, mental health struggles, and judicial authority colliding in real time. At the center of it all is a defendant facing a failure to stop and give information charge after a hit and run. But that's just the surface. Because once the facts come out, this case reveals layers that make it far more serious. Prior felony probation, allegations of intentional impact with a vehicle, and a judge who is clearly weighing public safety over personal hardship. Add to that emotionally charged claims of discrimination, a commercial driver's license hanging in the balance, and a bond decision that could change everything. And suddenly, this hearing becomes a test of accountability, credibility, and consequences. As you watch, pay close attention to how the judge listens when patience runs thin and how quickly demeanor becomes evidence. And ask yourself early on, where does empathy end and responsibility begin? Because by the end of this clip, that question becomes unavoidable.
I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
It's
not.
so true. It's so true. And you know this. You know what I'm talking about.
All right. Good morning, Miss Gill.
Good morning, Your Honor.
I wanted to bring you out because we're talking about you, and it's only fair that you get to hear what's transpiring since these are your cases.
Yes, sir.
I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Or, well, hold on. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On March 25th, 2025, officers were dispatched to 15357 Wallaceville Road in Tarrant County, Texas, regarding an FHDI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallaceville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited, and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed
This is the
backward.
moment the case shifts from traffic incident to something far more serious. A failure to stop and give information is already a criminal offense. But when the allegation turns into intentionally reversing and striking another vehicle, the legal stakes skyrocket. Intent matters. A lot. Because intent can transform a negligent act into reckless or even assaultive behavior, especially when a vehicle is involved. Listen closely to the details. The complainant follows for miles, demands insurance. The defendant refuses, leaves, comes back, then reverses, allegedly hitting the car again. From a legal standpoint, prosecutors don't need to prove motive here, just that the action was deliberate. And that allegation alone is why the judge's tone begins to harden. So here's the engagement question for you. At what point does self-interest cross into criminal recklessness? If you're hungry, stressed, or overwhelmed, does that ever excuse behavior that puts someone else at risk? This is where sympathy and legality begin to separate sharply.
Proceed backwards, hitting the complainant's vehicle a second time. The
So
complainant.
are you telling me that now it was intentional?
Sure. The complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who struck her vehicle. The estimated damage from the complainant was around $4,000, and the defendant stated she didn't stop because she was hungry and colored.
And what?
Colored.
Color.
Yes, Your Honor.
Can you look up to see if she has a valid Texas driver license?
Yes.
Ms. Gill, I'm going to find that there is sufficient probable cause to go forward with your case. Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle, and now an FSGI. I am taking away your privilege to drive. You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt. I can have a contempt hearing. I can have a contempt.
After.
Finish.
I'm so
please.
sorry.
Finish.
I'm a commercial driver.
Really?
Yes.
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail.
When the judge lists the defendant's criminal history, everything changes. This isn't happening in a vacuum. The court isn't evaluating just this incident. It's evaluating a pattern. Felony probation for assault on a peace officer. Felony probation for injury to a child. An evading arrest charge. And now, another alleged offense involving a motor vehicle. Legally, this matters because bond decisions are about risk. Risk of reoffending, risk to public safety, and risk of noncompliance. The judge has clear authority to revoke driving privileges, impose affidavits, and even hold someone in contempt for violations. That's not personal, that's procedural. And a CDL issue adds pressure. A commercial driver losing driving privileges is devastating. But legally, the court's priority isn't employment. It's safety. So ask yourself, should prior convictions weigh more heavily than present hardship? Or should courts treat every case as if it exists in isolation? This judge makes their answer very clear.
And a $500 fine. I truly am at a loss with the attitude.
Okay.
Truly.
Okay.
This case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally. Because
Wow.
allegedly hungry and covered. So now, this is an affidavit, and I hope that you take it seriously. Because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor.
May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. She has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and she is willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100. And
So I appreciate your argument. She's technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what, Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road, is that you are a danger to the public, and your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always, I mean, really,
don't say anything.
how many people died this weekend on the road because of the reckless and wanton actions? All we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping
Don't
me.
say anything.
I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this. Okay? I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children. My children have trauma, okay? And I have no insurance for the medication, and I
This is
have
one of the
not been
most
on.
emotionally charged moments in the entire hearing. The defendant isn't arguing law anymore. She's arguing life. Trauma, abuse, children witnessing violence, untreated mental health conditions, lack of insurance, all laid bare in open court. And this is where courtroom reality becomes uncomfortable. Pain can be real, and consequences can still apply. Judges hear stories like this every day, and that doesn't make them heartless. It makes them cautious, because the law doesn't punish feelings, it punishes actions. The judge even acknowledges understanding, but draws a firm line when it comes to personal responsibility. This moment forces a difficult question for viewers. Should mental health struggles mitigate accountability or explain it without excusing it? There's no easy answer, and the courtroom doesn't always have the luxury of one.
I have not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
Okay.
I understand that, but at some point, your actions become your own, right?
You don't understand. I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
It's
not.
so true. It's so true. And you know this. You know what I'm talking about.
I call out.
This is where the conversation pivots into one of the most sensitive and explosive areas of the justice system: accusations of racial discrimination. The defendant believes her treatment would have been different if she were another color. The judge doesn't dismiss the concept outright, but firmly separates systemic issues from individual case facts. That distinction matters legally. Courts rule on evidence, records, and conduct, not assumptions. The judge explains exactly how decisions are made: paper, history, documented behavior. Whether viewers agree or disagree, this exchange highlights a hard truth. Perception and proof are not the same thing in court. So here's the question that deserves serious thought. How should courts balance lived experience with legal evidence? And can someone feel genuinely discriminated against while still being lawfully sanctioned? This moment alone will divide opinions, and that's exactly why it matters.
Not read me my rights.
Well, I will let
They've been mishandling me like this for years already, okay? I have the right to tell you this. And I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
This hearing ends with a compromise, but not a victory. The judge lowers the bond back to $1,000, refuses a personal recognizance bond, and makes one thing unmistakably clear: do not drive, do not reoffend, do not test the court. The ruling reflects a balance between compassion and caution, recognizing hardship while prioritizing public safety. Legally, this case underscores how bond decisions hinge on history, demeanor, and risk, not just sympathy. It also highlights how quickly a traffic-related incident can escalate when prior convictions, alleged intent, and courtroom conduct come into play. The broader implication is simple but powerful. Courts can acknowledge systemic issues, but still enforce personal accountability. Now I want to hear from you. Did the judge get this right? Or was this an overreach? Drop your thoughts in the comments. And if you found this case as shocking as we did, make sure to hit that like button, share this breakdown, and subscribe for more jaw-dropping courtroom commentary and legal analysis. Balance scale fire.